Good morning, everybody. My name is Marty Mascari. I'm so sorry. If I can shut my phone, ringer off. Sorry. Sorry, that's my office phone. Sorry. My name is Marty Mascari. I'm with the North Central. I'm a contractor with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, ADRC, both of which are under the umbrella of the North Central Texas Council of Governments serving the greater Dallas-Fort Worth area. We welcome everybody from everywhere, but to join us for today, we're here with our cohorts and friends at Heyman Hogue to talk about blended families and all of the things that go along with blended families. Before we turn it over to Rex, Sheila, if we could advance this, or Rex, if we could advance the slide, and then if Sheila could talk to us about CEUs.
Good morning, everyone. And if you heard me talking earlier, today our CEU, we will be giving credit to attorneys, which are called CLEs, and we will be giving credit to social workers of all types, LPCs, LCDCs, anything like that, licensed professional counselors, and assisted living managers and social workers. Yeah. So no nurses today. Now, the nurses will come back online in January, but in addition to all the rest, but we will be giving credit. And how do you do that? The same way you always do. You will receive in the follow-up email from Marty, you will receive an eval and a sign-in sheet. Please fill those out and send them back to me because my email address will be on there, sheila@heymanhogue.com, and then we'll be more than happy to send you your certificate. That's it.
Great. In addition to that, there is an evaluation form that you will fill out and email to Sheila, but there's also a Google evaluation form that should pop up as you close out of Zoom today. It usually gives you the option to go there to fill out. We ask you to fill out the the Google evaluation form if you would. It helps us reporting back on our goals and objectives we set forth when we applied for the funding to do these. I'm going to let Sheila, if you'll introduce Rex, and we'll get rolling.
Well, good morning again. Today we have for our Brady Bunch, and Rex, you can go ahead and advance the slides. We have Rex wrote this program because we have so many people coming into our office that are blended families and do not realize the consequences that can arise. If you have no planning, if you have poor planning, but then he's going to show you if you have good planning, what can happen. He's going to answer your questions as best he can. If you heard earlier, he's got a hard stop at 11:30. So please hold your questions to the end and we'll try to get to as many as we can. Here's founding partner and my friend, Rex Hogue.
Thank you, Sheila and Marty. Today we're going to talk about America's favorite blended family, the Brady Bunch. I won't take time to have y'all sing the song. Basically, we compiled facts from the show. We compiled facts from later specials and movies. We've added assets that we find are typical of blended families, and we've added situations that don't conflict with the facts and are samples of situations any family might run into. So where we're starting is about the halfway point through the show. Mike is 44, Carol's 43. They married 3 years ago. They have a prenuptial agreement. Mike's kids are Greg, Peter, and Bobby, age 17, 14, and 11. Carol's kids are Marcia, Jan, and Cindy at 15, 12, and 9. And Alice is the housekeeper. Mike married right after college. He took a job as an architect with Phillips firm in Plano. Many people don't know the show is actually in Texas. That is one fact we changed. It's moved it here. He became a junior partner, 10% partner 6 years ago. His first wife died 5 years ago. His grandfather was Judge Brady. He owns a 3,000-acre ranch, and it includes oil and gas royalties. His father retired as a petroleum engineer and are now known to the kids as Paul and Grammy Brady. He had a lot of oil stock when he retired. and he kept 40 acres of the ranch when he sold it. He still lives there, and they have a few cows, some horses, and chickens. He put half the sale proceeds into more minerals and half into oil company stock. Now, Paul and Grammy Brady love having the kids come out to the farm, or ranch as they call it. They adore the girls, and they keep the boys for a week in the summer and the girls for a week in the summer. They do it separately, so they tend to do different things with both of them. Now, future plans, Mike intends to keep that 40 acres after he inherits it as perhaps a family vacation spot, Christmas home, or just place they could go for the weekend. Carol grew up in Massachusetts. She married and she moved to Texas. She was divorced 6 years ago. They have joint custody. However, he lives out of state and only sees the girl once a year, but he does have monthly communications. She feels like the lack of planning cost her a lot in the divorce, and it wasn't necessarily estate planning, but just financial planning and some other things. She wants to keep separate properties separate. She's learned, hey, when it gets mixed, that can be disastrous. She has a brother named Jack and his wife Pauline. They live in Austin. And Carol and Jack were close. But then Carol's parents were in a very bad car accident. Her father was killed. Her mother, Connie, was brain damaged, but she did recover physically. And we're going to walk you through what kinds of things they had to go through. Carol's parents had no estate planning. So for her dad, they had to go through probate in 3 states, Massachusetts, Colorado, and Texas. And a little later, I'll explain why they had to do it in 3 states. Then they had a guardianship for Connie originally in Massachusetts, but then they moved it to Texas. And she lives in an assisted care facility in Austin. And tension has developed between Jack and Carol regarding their mother's care. And we have found that when you have multiple kids, that can happen. They don't always see things the same way when it comes to the care for parents. Jack wants to put her in memory care, and Carol thinks they just don't want to deal with her mom. And so she's thought about moving her mom here. Well, then she got a call from her brother that she could expect a call from the FBI. Her mother had told him that she believed the place she was living in was crawling with German spies, and she wanted him to call the FBI. And then she had identified a resident that she believed was one of the spies, and she actually attacked him with a cane. Now, you may think that's a crazy situation, but we actually have had those things come up in real cases. So they were forced to make a difficult choice. Either get Connie out of that facility entirely or move her to the memory care portion where they could keep a better eye on her. Now, that's the family background. Let's look at the assets. And by the way, when we start planning for families, I always try to learn about the family before I learn about the assets, because that kind of puts the assets in context. They have a joint home, checking and savings. They've got household goods. Mike has a 401k from work. They've got 2 cars. They've got life insurance on each of them. But they've got the beneficiaries are either the spouse or their own kids. Mike has an IRA he no longer contributes to after the marriage. The Phillips firm, his 10% interest, is his separate property, and that's because of something known as the inception of title rule. It was his separate property when they got married, and it remains his separate property. Carol has an IRA she no longer contributes to. And then they got a prenuptial agreement the attorneys advised each of them to stop contributing to the existing IRAs and open new ones. So they kept those IRAs as separate property. They actually did get some good legal advice there. Now, right now they have no planning. So what if one of them becomes incapacitated? Well, they're looking at a guardianship. We won't spend a lot of time on guardianship, but we will talk about what that looks like. Then what happens if one of them dies? That's going to mean probate. The home would then be owned half by the surviving spouse and half with the decedent's kids. And given that the kids are minors, that's going to create problems. That home will be under a guardianship for the kids for years. The life insurance paid to the kids will also be under a guardianship. The community property will go half to the surviving spouse, half to the decedent's kids. And the survivor does not owe the decedent's kids anything past the age of 18. 1/3 of separate property would go to the surviving spouse. Now, what if you have no plan? Well, we've got an 800 number that you can call. This is what their plan would look like. Yep, 1-800, you blew it. Carol's already seen that with her own family. Now, from an estate planning standpoint, I tell people there are 3 dragons we plan for. The first are what I call the administrative dragons. That's power of attorney failures, and powers of attorney fail frequently. Guardianship and probate. Then what about medical documents, making medical decisions? We refer to these as administrative dragons. Then there are tax dragons. There's all kinds of taxes that we may have to deal with: capital gains taxes, gift, estate, and generation skipping transfer taxes, business entity taxes, and we deal with things like the entity taxation, the tax method, and audit risk. Now that's a big, nasty, fire-breathing dragon. And then the last group of dragons is what we call the predator and creditor dragons, and I tend to just call them the predator dragons. But with this, you need to look at protecting yourself and protecting what you leave others, and we're going to show you how that works. Now, I want you to notice that that dragon just kind of came flying out of the sky. When we talk to people and they tell us about lawsuits they've been in, I frequently hear this: that lawsuit came out of nowhere. Folks, there's no such thing as a lawsuit that comes out of nowhere. Lawsuits occur when a triggering event meets risk. That's where lawsuits come from. And if you know what your risks are, then you'll know where lawsuits can come from. Now, the administrative dragons, I'm going to start with incapacity. And there's 2 aspects of incapacity. The first is medical issues. We have 6 key medical documents that we use. The HIPAA patient authorization authorizes someone to gather medical information, and it works in conjunction with the durable special medical power of attorney. Now, having a medical power of attorney but no HIPAA authorization may force your medical agent to make decisions about you without the adequate medical information they need to make an intelligent decision. Then we have a document we've developed called Personal and Healthcare Instructions. And it's not a legal document, but we use it to help people figure out, this is what I would want if I were in this situation or that situation. And it's really our response to the Terry Schiavo situation from a number of years ago. Then we have the directive to physicians, and that is also known as a living will. And then the anatomical gift form. And there's 2 things on the anatomical gift, and everybody should sign this form. One is whether or not they want to make anatomical gifts, and no is a perfectly acceptable answer. And the other is whether you would be willing to undergo an autopsy that's not required by law. Again, no is an acceptable answer. Yes or no's tell your family what you want. Finally, there's the disposition of remains form, and that authorizes somebody to make final arrangements, particularly funeral and those kinds of things. Then there's a medical form service we use called DocuBank that they can, they keep these documents on file and they can get them to any hospital in the world 24/7, 365. We have had our clients use DocuBank at 3 o'clock in the morning on a Saturday. Now, the other side of incapacity is what I call the financial or legal side. And most people think of a power of attorney. That's a document where the principal gives an agent a power of attorney. It's really an invitation to third parties to let the agent act on their behalf. Now, a lot of people are surprised to learn that powers of attorney frequently fail. I don't have time to really explain today why they fail, but I've been doing this for over 30 years and I can promise they fail a lot with a lot of different institutions. Now, if the power of attorney doesn't work, there are two plan Bs. The first is a guardianship, sometimes called conservatorship in some states. And I define that as the court-supervised management of assets for somebody who is legally incompetent. Some people call it living probate. The other possibility is a living trust. It can replace the power of attorney. It provides a necessary substitute signature, which I'm going to get to in a minute. It avoids guardianship and probate, and it can provide instructions for an incapacitated person's care. And I'll give you an example of that. When my mom decided she wanted to go to a facility, instead of my brother, she was going to move to San Antonio near my brother. Instead of my brother having to go find out what every place in San Antonio offered, I sent him the checklist from Mom's Trust, where she said, if I have to be in a facility, these are the features I want. And it took my brother 20 minutes to find two places within 10 minutes of his house that met all of Mom's criteria. And even though he originally said this would take months, she moved 23 days after the phone call telling us she wanted to. Now, guardianship and probate are caused by the same problem. While they're very different procedures, the basic underlying issue is the same. The problem is a person is unable to sign necessary documents to manage or transfer assets. Guardianship and probate solve that problem by having a judge authorize a substitute signature. Frequently, they are the only solution to the problem. My question is, are they the best solutions to the problem? Well, guardianship, I tell people it's one of those 12-step programs that nobody really wants to be involved in. The minimum cost is between $9,500 and $30,000 a year. Now, that's not the cost for one of the attorneys. There's at least two attorneys involved. There's a lot of steps that take place. It's expensive and it can take months. The annual cost, I've been told, can be as little as $2,500, but it's usually going to be more than that. And it seems like a constant stream of surprises that goes on for as long as the ward is alive. It's disastrous for otherwise good estate, business, and asset protection planning. Guardianship leads to a lot of time. It takes months to get it in place. It takes a lot of time working to get through the process. It costs a lot of money. You're going to have at least two lawyers, a doctor, and likely a social study, the cost of which will come out of the estate. It involves a lot of going to court. Usually takes multiple hearings with at least 2 lawyers. Then there's a loss of control. The person who is the ward loses complete control of everything, and they also lose some constitutional rights. There's also a loss of dignity. It's not fun to have your family testify in court that you're incompetent, and it's not fun for the family to have to do that either. It's also a major asset protection problem because it opens a door for creditors and predators that is otherwise shut. All they have to do is attach their claim to that guardianship. Now, here's how you wind up in guardianship. A person owns assets in their own name or any form of joint ownership. And this could happen on the incapacity of any owner. Had a case one time I reviewed where the house had been damaged in a spring storm. About a 3-inch hole was poked in the roof by a branch that fell on the house, and the wife's husband was incapacitated. And she ultimately had to go to a guardianship because she couldn't get a contract signed without him. She couldn't access his accounts, and that's the most unusual guardianship reason that I've seen. But on incapacity, you go to the probate court for the guardianship of the estate, which can be very difficult, or the person, which is usually somewhat easier. Now, if you happen to be a business owner, you're going to see that we don't have an arrow here because it depends on who owns the business. The alternative is a trust. Even with a trust, you can still become incapacitated, but the rules are very different. The assets are then managed by the trust. In that sense, the trust replaces the power of attorney. An institution can refuse to deal with the agent, but they cannot refuse to deal with the trustee because the trustee holds legal title to the assets. It can avoid guardianship, provide incapacity instructions like we had with my mom. The successor trustee manages it. It's typically easy to manage, change, and update, but it works best when the assets are fully aligned with the trust, and some people call that having the trust own it. Now, how does this apply to the Bradys? Well, Connie went through guardianship in Massachusetts. She had to get permission to get her and the guardianship transferred to Texas. Jack handled most of that, and it wasn't an easy process. It was very expensive and time consuming because there was no planning in place. The Texas court required a 3% bond for guardianship assets, and that's normal. And that can cost thousands of dollars a year because it has to be renewed every year. Jack is paying that, but that will eventually have to be repaid. Now, just think about this. What if Jack couldn't afford it? That could be a huge problem. The court has to prove any changes for her or the assets. There's a complete financial accounting every year, and they concluded this is a nightmare they want to avoid. So Mike and Carol, they've had enough of guardianship just watching Carol's mom go through it. Now, on death, everything goes through what I call the estate settlement cost funnel. There are 4 types of expenses that come out. Administrative expenses, and this raises 3 issues. Which rules apply? How many different rules apply? And where do you put your family in this process? The second expense is probate. Now notice it's in red, administrative issues are in green. The reason for that is you're always going to have some administrative costs. But probate, you can avoid generally with good planning. And the next one is creditors. Those can also sometimes be avoided by good planning. Then there are tax issues. You can do tax planning and avoid tax issues. But be aware that if a Form 706, which is the estate tax return, is needed, Administration costs are going to increase. Now, after you turn all of these spigots off, then you open up and whatever's left over comes out the bottom. And this is where we get into other administrative rules. Now, there are 4 ways that assets pass. And by the way, there are only 4 ways. So think of this like when you go to the grocery store, at least in the old days when they would scan every item in your cart. Only we're going to pretend like they're going to put those items in one of 4 bags. The very first thing we look at in administration is, was that asset owned jointly with right of survivorship? If so, it passes directly to one or more individual survivors. If it doesn't pass by right of survivorship, we ask if it passes by beneficiary designation, like life insurance, annuities, retirement plans, or a TOD, which stands for transfer on death. I refer to this as planning by the box. I call it that because there's a box on a form that says, if something happened to you, where do you want the assets to go? Whatever you put in that box, that will dictate the rules. Now, if you name individuals, it's going to pass directly to those individuals. Now, these two look very similar. It's not the same from the top to bottom between right of survivorship and beneficiary designations and TODs, but they're the same once you get there. And here's 2 problems you can run into with all 3 of these methods of passing assets. You can lose complete control over the assets, and they will both blow any tax planning you may have done. Now, if it doesn't pass by beneficiary designation or TOD, the next question we ask is it owned by a trust? If so, it passes according to the trust terms. If it isn't owned by a trust, there's only one thing left. It's owned by an individual, it's going to go through probate, and it's going to be controlled by the will or intestate succession. Now, in case you're wondering, intestate succession is the will our state legislature has graciously written for you in case you didn't write a will or your will isn't valid for some reason. Now, those are the 4 ways of passing, but let's look at a couple of things going back to the box to start with. You can name the trust in the box and the assets will pass according to the trust terms. And if the box fails or you really want to, you could name the estate and it'll go through probate. Now, if we have a trust, but we still have to go through probate, we use what's called a pour-over will, which will pay the assets to the trust so that the assets are still passed according to the trust terms. Now, all 4 of these methods get assets to beneficiaries, but they're not equal. So let's look at administrative rules. Now, you always have to consider case law, banking regulations, the Internal Revenue Code, and Treasury regs. But with right of survivorship, beneficiary designations, and TOD, there is one common set of rules. The first thing you should note is that the Internal Revenue Code has special bad tax rules that apply to those ways of passing assets. Then, right of survivorship, or contract as this is called, you go through in each state where there are owners, survivors, beneficiaries, or where assets are located, there can be other laws that come into play, like the estates or the probate code, the property code, the insurance code, or the family code. With the trust, there is one set of rules, the Texas Trust Code, assuming it's Texas Trust. The trust allows faster access to assets than any other method. If it's owned individually, you have to go through probate in each state where there is a real property interest owned. And that brings up their estates or probate code, the property code, and perhaps other laws. Now, if you just take a look at the administrative rules and you really get this, you'll realize that trusts are the easiest way to pass assets. There are fewer rules involved. I didn't say it was easy, but it's easier than these other methods, especially if things go wrong. A lot of people overuse right of survivorship and beneficiary designations. Now, probate technically means to prove up the will, but I prefer the layman's definition, the court-supervised transfer of assets for someone who has died. Now, Texas has a lot of probate procedures. I'm not going to go into all of them. This is an overview of probate, but people want to know two things. They want to know, how much does this cost and how long does this take? I tell people, nobody can tell you that if they're being honest. I tell them, if you call a law firm and you ask those questions and they give you what appears to be a straight answer, they will lie to you about other things too, because it isn't possible to know. I'm going to show you why. If you knew to ask, this is what you should ask. Who gets paid first and who controls this process? So straight out of the Texas Estates Code, funeral and last illness up to $15,000 each if the court approves. Now, when you see phrases in the law that say if the court approves, courts approve things by lawyers going to court and arguing it. It's not the cheapest way to get things done. Family allowance for 1 year if there are qualifying family members. Cost of administration, attorneys, court costs, executor fees, preserving, managing, safekeeping the estate, and unpaid guardianship fees. That comes as a surprise sometimes. Then secured claims and tax liens, unpaid child support and interest. Then comes taxes, penalties, and interest. That's the IRS. I think it's really cool that Texas managed to put 5 people in front of the IRS. Then cost of confinement if a person was in jail or prison, repayment of medical assistance if they're on Medicaid and Medicaid recovery, and then other claims. And I don't have time to tell this story, but if somebody owns rental property and they go through probate, they may find their kids can't get rent until the end of the lease. I've seen that happen. Now, I don't know if you noticed who isn't on the list, but I'll just tell you, it's the family. They're last on the list. Okay, it's nice to know the order, but who controls this process? The process is not controlled by the courts or the attorneys. It's controlled by all these people who might make claims. No one can tell you for sure how many claims will be made. No one can tell you what it will take to resolve those claims. Nobody can tell you how much it will cost to resolve those claims, and nobody can tell you how long it will take to resolve those claims. The typical probate in Texas, in my experience, lasts from 8 to 12 months, but I've had one that lasted more than 3 years one time. It's kind of a crapshoot. Texas has one of the best probate systems out there, though. However, let me give you my definition of probate. It's really a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit predators. And I've, by the way, given this definition to some probate judges, and their response has either been, "You're right," or "I can't say you're wrong." I've yet to have one tell me, "You're out of your mind, you're wrong." Now, how does this apply to the Bradys? Well, upon the death of either, the home would be jointly owned between the survivor and the kids. That's going to require probate and a guardianship for the kids, but don't worry, that guardianship will end when the youngest turns 18. The spouse has limited options. Mike's 401k would go to Carol. She could roll it over, and his kids may never see it. That happens sometimes. Life insurance, kids as beneficiaries, going to require a guardianship, but at least when they turn 18, they're going to get their share. Does that really sound like a good idea? It isn't. Then there's going to be a guardianship if the survivor is incapacitated, and probate upon the survivor's death. And I've had people say, hey, life insurance and 401ks and right of survivorship, they avoid probate. No, they postpone it, and they may require a guardianship. Now, what is a trust? It's a contract that involves three parties. The trust maker, they go by other names, they make up the rules of the game. The trustee manages the assets according to the rules the trust maker set up, and they do it for the benefit of the beneficiary. Most of our clients set up the trust and they serve in all three roles. But when they're no longer able to serve as a trustee, other trustees manage it for their benefit. The trustee holds assets for the trust. That's often stated as the trust owns the assets. And assets in the trust avoid guardianship and probate. Now, while a person's alive, trusts avoid guardianship. They provide instructions for care, or at least they can. We see a lot of trusts that don't, though. They can give you a chance to see how a successor trustee manages the assets. Easy to manage, change, and update, but again, best when assets are transferred into the trust. And that's what we mean by assets fully aligned. After death, assets owned or controlled by the trust avoid probate. It can provide distribution instructions for all of the assets. One plan that does it all. Faster access to assets. It's faster to and easier to administer. You have fewer complex rules than right of survivorship, beneficiary designations, and probate. It involves only one state's law. It provides more certainty of results than any other distribution method. Now, what a trust could do in this case is pass all the assets by terms of the trust that are more favorable to everyone. It'll avoid probate. It can protect the spouse from existing creditors, future lawsuits, and divorce if remarried, if you structure the trust correctly. It can avoid guardianship for the children, provide for their college education, and protect the kids from their existing creditors, future lawsuits, or divorce in the future. Now, we use something that we call our Family and Money Protection Plan. It's going to include medical documents for both, plan for the possibility of incapacity for either, provide instructions for the incapacitated spouse, avoid probate, guardianship for the kids, and it's one vehicle to transfer all the assets. The kids will get a college education, at least up through a bachelor's degree. Now, here's the plan that Mike and Carol came up with. They have charities they want to benefit. Big church in Frisco, $10,000. And then Carol wants to give $10,000 to Mothers Against Drunk Drivers. Her parents were hit by a drunk driver. The community property, they want to give 1/7 to each child and 1/7 to Alice because she's really a big part of their family. The survivor is going to get the house in exchange for other assets. So instead of splitting the ownership with the kids will get other assets instead, and that way the spouse can control the home. The B share protects the survivor and the decedent's children in case the survivor remarries. And it's going to be enough to get the kids started in life. There's separate property, some benefits surviving spouse, some goes into trust for the decedent's kids. So just because it's separate property, sometimes people want the spouse to benefit, sometimes they don't. And sometimes it depends on the asset, as you're going to see. But it all ultimately goes to the decedent's kids. Now, we're going to do a little time traveling. We've developed this technology. But instead of going into the future, we're going to move Mike and Carol 21 years into the past. And we're going to look past that original plan they did and see what's changed in 21 years. Now, I will tell you, we hope that Mike and Carol have come in the interim But now Mike is 65, Carol's 64, Greg's 38, Marcia's 36, Peter's 35, Jan's 33, Bobby's 32, and Cindy is 30. They're grown up and have their own families. So we're going to walk chronological of events, that took place since the first plan. Carol's mother died 19 years ago. It took 3 years to get everything through probate. Probate was more expensive than expected, but she inherited a condo in Colorado and 2 rental properties in Texas and some money. Paul Brady passed 7 years ago from cancer. That happened when Cindy was in college. Good planning made that estate settlement simple. Mike helped his mom, Grammy, sell the ranch. It wasn't practical for her to live out there anymore, so she is now into an appropriate location for her independent living. So she has people her age she can do things with, but she lives close to Mike and Carol so they can see her. They moved Grammy to assisted living, and the good planning made her incapacity very simple to deal with. Grammy died 5 years ago. Now, Paul asked Mike to divide any leftover ranch proceeds by 9 on Mike's death. Each boy would get 2 ninths, and each of the girl would get 1 ninth. Now, they did that because they wanted to do something for the girls. But think about this. How are the boys going to feel about part of that ranch going to the girls? It's been in the family since their great-grandfather. They may resent that. This could create a rift in the family. We're not saying they shouldn't do it, but it's definitely going to require some planning to avoid problems in the future. The oil and gas revenue goes straight to the boys on Mike's death. The oil company stock ultimately goes to the boys, but Carol can benefit from it while she's alive. Sam retired and he and Alice moved away 5 years ago and really no longer part of the family. Now, 16 years ago, Carol bought a real estate business, partially with inherited money and partially with community money. And we're just going to call it 50-50 of each. Mike is now retiring as a senior partner. Unfortunately, he's been diagnosed with stage 3 multiple myeloma, and frankly, his future's looking a little rocky. He's likely to be in a wheelchair in 1 to 2 years. His life expectancy is 4 to 6 years. Carol put her company up for sale so she and Mike could travel and do things while he is still able. Preparing for Mike's incapacity, obviously he's going to likely be facing some issues, and we can plan for that if we kind of know what's coming. So they sold the home. They bought a single-story home and downsized. Now Greg, he's 38. His wife Nora was a nurse. They have a son Kevin, and Mike and Carol adore Nora. They are concerned, though, if something happened to her, Greg might fall for a gold digger. Greg's always been kind of a ladies, man, and they didn't always approve of all the dates he had. He's an obstetrician. He's done very well financially. They don't need Nora's income, so she quit nursing to go into a catering business with other family members. They own a beach house, and they've let everybody in the family use it at no cost. And Greg refers to the girls as his sister. He feels close to all of his siblings and his parents, and he looks out for everyone. Peter's 35. He served as an officer in the Air Force, and that really changed him and gave him direction after his service. He's got a business degree. He's good with money. He has 1 broken engagement. Greg still continues to introducing to women, but hadn't worked out yet. He's in business with his brother, Bobby. That'll be on the next slide. And he is happy to help his injured brother. He remembers Greg paying for him to fly home for Christmas one year while he was on leave. So he's very close to his brothers, but he sees the girls as stepsisters. He's closest to Jan of the girls. Bobby became a race car driver, but a crash left him significantly disabled. He was paralyzed for a while, but he's going through rehab. He is improving. He went back and got his business degree at 28, and Mike and Carol paid for that. He's good with money, but he's not able to make as much because of physical limitations. But that means Mike and Carol want to make sure that Bobby is at least taken care of and consider his physical limitations. He's married to Tracy, and Mike and Carol really love Tracy. Peter also likes Tracy, but he doesn't want to be in business with her if something happens to Bobby. And that, by the way, is not uncommon. He sees the girls as stepsisters. He's closest to Cindy and then to Jan. Tracy is in business with Nora, Marcia, and Wally. That'll be coming up on the next slide. Marcia Brady Logan is 36. She's a college grad. She became a fashion designer. She married Wally Logan, who's a likable, fun-loving toy salesman. Unfortunately, he's often out of work. She's had an alcohol problem, but she hasn't had a drink in 3 years. She stays home with the 2 kids. She's still popular and outgoing, but she's not really a very good decision maker. She's not good with money, and neither is her husband. Mike and Carol have helped them financially in the past. And folks, if you're not getting this, we're just throwing things out here that can cause issues between the kids, but also show that you may not want to treat everyone identically because they're not all in the same situation. That doesn't mean you have to give them a different amount of assets, though. She's close to Greg, and she really likes Nora. She sees Peter and Bobby as stepbrothers, though. But she does like Bobby's wife, Tracy, well enough to be in business with her. Jan Brady Covington is 33. She's married to Philip Covington, and he was one of her science professors in college. She became an architect at the Phillips firm. They can't conceive. They adopted a Korean girl named Patty. She's still jealous of Marcia's popularity and personality, but she's past Marcia in a lot of ways. Jan is a good decision maker. She's good with money, and so is her husband. She might be up for junior partner with Mike retiring. She's closest to Peter and Bobby, but she looks up to Greg. She really sees all of the boys as her brothers. And Mike and Carol really like Philip, and they think he's really good for Jan. Cindy Michaelman is 30. She's a college grad in mass communications. She's a radio DJ. She married her boss, Ken Michaelman, a Jewish widower, more than 15 years her senior, 2 years ago. She married a year after his wife died. They didn't have an affair before. They just got to be really good friends quickly, and he was lonely. She has 2 stepchildren. She's 10 years older than the oldest one. And that can create problems between her and her stepdaughters, who think, man, she's just kind of like an older sister, except more annoying. The children were 18 and 16 when they married, so she didn't really raise them. Ken is good with money. He's very conservative. And Mike and Carol like him. He's been good to Cindy, but he overshadows Cindy. They see rifts between the sets of kids and between the girls. And we'll kind of talk about perhaps some of the reasons here in a minute. The firm insurance should cover Mike's medical. but they're concerned the girls might not understand Mike's business being his separate property since they didn't know he was a partner before he and Carol married. They're hoping for the best for the business with the two daughters-in-law and Marcia and Wally, but they're concerned that a business failure could create a huge rift in the family, mostly because half of their kids, one way or the other, are involved in this business, maybe even four of them. Now, Greg, in years past, had loaned Peter and Bobby money interest-free for their business, and they paid it back. Greg has told Mike and Carol privately he's concerned that Marcia and Wally may not pay him back, but she's still his sister, and he loves her and does want to help. The boys might not understand why Pa and Grammy wanted to give the girls proceeds from the ranch that was their great-grandfather's. And they already kind of see, with the exception of Greg, not as sisters but stepsisters now. Marcia and Cindy have mentioned they think Carol's real estate business should be her separate property, since Mike's business is his separate property. The girl's father has been more actively involved in the picture for the last 6 years. He has two stepchildren the girls know and seem to like. And for the last 4 years, their father and his new wife have paid to take both their sets of kids and their families on a vacation. So they're developing a relationship with their step-siblings from their father. And they're likely going to inherit an unknown amount from him. Marcia appreciates Greg. She thinks Jan believes they're still in competition, and she sees Cindy as the baby of the family. She thinks Peter and Bobby benefited from a lot of things other than their own hard work and good choices. She doesn't understand why Wally hasn't been as successful as the boy. He's a lot of fun, even if he's a little quirky. But she loves Wally, and everybody loves Wally. He's just not been very successful. Now, Marcia may feel like the family failure, though she's unlikely to admit it, and she might resent the others doing better. Now, for assets, Mike and Carol have a home, a brokerage account, checking and savings. They've got household goods. They've got Mike's 401k and IRA, and Carol's the primary beneficiary. Carol has a 401k and an IRA with Mike as the primary beneficiary. They've got 2 cars, life insurance on both, trust own, and is the beneficiary of that life insurance. That way, if something happens, those proceeds don't end up going through guardianship or even probate. The pre-marriage IRA, Mike's is going to the boys. Philip's architectural, he has a 10% interest in. He wants the boys to benefit from that, even though what's going to happen is they're going to have to sell the firm. By the way, he might want to sell that interest to Jan and give the boys the cash for it. And Jan would be in a position to do that, at least over time. With his inherited assets, he wants the oil company stock from Paul and Grammy Brady. He's got oil and gas royalty from Judge Brady, and he's got a gun collection. Carol has the pre-marriage IRA. It'll go to the girls. She's got 2 residential rentals, and Mike did a lot of free work on those. The brokerage account that she inherited, the Colorado condo she inherited, and a China doll collection that's, her mom loved China dolls, and Cindy is the doll lover in the family, and she currently has it. Now, Carol told Jan and Marcia that Cindy is holding it since they didn't have room for it after downsizing. Cindy's story that she's told Jan and Marcia is a little bit different. She told them Carol gave it to her. Now, we actually had this come up in a case one time, and that has the potential to create big problems between these sisters. Medical decisions, well, they want to make decisions for each other first, but then they want Greg. Greg's a doctor. He's going to be the best at making those decisions. And then Nora, she's got a nursing background. Then Jan, level-headed, and Peter's also level-headed. And then they want to benefit some charities. Now Carol wants to give $50,000 to MAD. They're in a better position. Mike wants to give $50,000 for cancer research because of his father's death. And they want to give $100,000 to their church. And they're still going to the same church 21 years later. Now, here's what the plan looks like. The community property, Mike's separate property, and Carol's property. And they want to take care of each other while they're alive. They've developed an AB plan. The survivor benefits from both shares. The B share goes to the first decedent's beneficiaries. It prevents disinheriting any of the children. It can reduce friction in a second marriage after death. The B share is not part of the survivor's taxable estate. So it can grow to any amount and not be subject to estate tax when the survivor dies. That removes the B share growth from the survivor's taxable estate. It can avoid capital gains taxes on both debts. That can be a bit of a tricky tax issue, but frequently in administration, we're able to accomplish that. And when one dies, they want separate assets for multiple purposes. Now, the AB plan, on the A side is the survivor share, and the survivor can give it to anyone they want. And it uses the second exemption plus any overage from the first exemption if they file a 706. On the B side, the deceased spouse's share, the survivor and kids benefit. The decedent's kids receive it upon death. It uses all or part of the first exemption, and the assets in this trust are asset protected. Little side note here, there's over 28,000 ways to legally draft a B share. However, we have eliminated all the ones that don't provide asset protection for our for the surviving spouse, and that eliminates about 2/3 of them. So most of the B shares I see are not asset protected. But this allows Mike and Carol to use 2 estate tax exemptions. Now, we've not really given you the amount of assets they may need to do estate tax planning. This certainly provides some of it. But anyway, that's how the AB works. Now, the community share is the simplest part to plan. It's divided equally between all 6 children. Mike's separate property, well, while Carol's alive, she's going to benefit from the income. Now, we have 2 separate property shares for Mike. And what he puts in separate one, Carol receives the income from. She can also receive principal for her health and maintenance. Benefits end, however, if she remarries. After Carol passes, 1/9 of the oil stock goes to each girl and 2/9 goes to each boy, and those stocks go in trust for those kids. Everything else goes to the boys in trust. Now, Mike's separate property too, this is the share that bypasses Carol. It all goes to the boys immediately in trust. For Carol's separate property 1, Mike benefits. He receives the income while he's alive, principal for health education, for health and maintenance, but his benefit ends if he remarries. After he passes, everything goes to the girls immediately in trust. Carol has some things that will bypass Mike, Those are in her separate property to trust. And when she dies, all of that immediately goes to the girls. Now, we don't have time today to show you how we might have done this in a hypothetical situation, but Mike and Carol, we build 7 trusts when we do a plan for a married couple. Most of them don't use all of them like Mike and Carol have, but they could. Now, let's talk a little bit about predator dragons, and here's the reason it's in trust for children. We define predator dragon and asset protection as protecting and preserving assets from unnecessary loss, and it can come from a surprising number of sources. Predator dragons, the biggest risk to your estate plan, this may surprise some of you, it's your child's spouse's divorce lawyer. They know more ways to attack inherited property than anybody else I know of. Beneficiary debts, like extraordinary bills, medical bills. I have a childhood friend who, about 3 years ago, she stepped on a step stool in her kitchen, slipped and fell, broke her leg, was in the hospital for 12 days, ran up about $325,000 of hospital bills. She's had 2 surgeries. And you may think, wow, but what happens here? Well, her parents could protect her so that those medical bills don't get paid by her inheritance. Greg has seen enough to tell his parents, protect your kids from that. Then there's predator threats, future lawsuits. Well, there's several questions we want to know. Does a beneficiary have a high lawsuit risk job? Greg does. What state do they live in? Some states you can do great asset protection planning in, some of them you can't. How would the loss of those inherited assets affect your beneficiaries? And how would you feel about that? What if what you passed along to your kids, they lost in a divorce or a lawsuit, or even like my friend and her medical problem? How would you feel about that? Well, again, this is a dragon that just comes seemingly flying out of nowhere. So here's 3 basic choices for beneficiaries. You can pay it outright. You could pay it in a convenience trust. You could pay it in a heritage trust. If you pay it outright, there's no protection from beneficiaries from lawsuits, guardianship, or probate. In a convenience trust, you can have some limited protection against guardianship and probate, possibly even the kids' bad money management, and maybe the IRS for estate tax. The heritage trust protects them from everything. And I'm going to give you an example of how that works. And it also has a dynasty trust provision. Now, Carrie was a young lady who inherited $3 million from her parents. One of my colleagues told me this story many, many years ago. He told it in a room full of attorneys. Well, he was telling us that he had passed $3 million with 0 tax back when the exemption was $600,000. Great job of tax planning. But she was involved in a car accident in Massachusetts. Somebody tried to go around her at an intersection, clipped her bumper, caused her to veer off, and she T-boned a van load of daycare kids. The driver and 2 kids were killed. There was a lawsuit over the accident. Carrie was found 10% liable. The guy who hit her was found 90% liable. Now, a lot of people think, well, that means Carrie had to pay 10%. That's sad. No, what's sad is Carrie lost her entire inheritance. Massachusetts is a pure joint and several liability jurisdiction, and if you're 1% liable, you can pay for the entire thing. If you happen to live in California and you heard about the accident, you can pay for the whole thing. Okay, I'm kidding about that one. But in Texas, the rule would have been she would have paid 10%. Compare that to another story. Ted got a little bit too much elbow exercise one night in 1969, and he drove off the Chappaquiddick River Bridge because he failed to negotiate it properly, and Mary Jo Kopechne died. Now, the Kopechne family discovered that Ted Kennedy's inheritance came down to him in what we call a heritage trust. They could not touch it. Now, after one of our other colleagues in that room shared this story, I realized I had not been looking at these quite the right way. It's up to clients whether they want to offer this protection. It's available to anyone who hires an attorney who knows how to go create this. Now, I'm going to wrap it up here. Just know that when we plan, we analyze the situation, family situation, financial situation, figure out what the goals and objectives are, then analyze the specific tools considering the family situation, financial situation, and goals and objectives. Then consider, what are you trying to protect? From whom are you trying to protect it? And what tools might work in your case? Every case is different. So prior to planning, we see this guy holding his bag of money. Those dragons are going to come. And this, being America, eventually one of those dragons will come take the assets that aren't protected. So what we try to do, same situation, but we build a castle around him. Now, dragons are still going to come. However, not only do we now make it difficult because they have to get through the castle, but we have a knight who can come out and slay those dragons. At this point, I'm going to turn this over to any questions we may have. Any questions?
Yes.
Okay.
Antoinette would like you to answer, why do powers of attorney fail frequently?
That's a great question. So with powers of attorney, let's just use a bank. Let's just pick a bank that's based in New York. They have to comply with New York law, Texas law, and federal banking regs. There might be conflicts between those. They don't know if you're still alive. When a person dies, that power of attorney dies when you do. How does the bank know you're still alive when your agent walks in? How do they know you haven't revoked that power of attorney? So institutions are reluctant to take powers of attorney because they're liable for what goes wrong. And I don't have time to go into it, but our legislature basically requires that they take the power of attorney, some glitches in here, but within 24 business days, that's 32 days in real time, and they've given institutions up to 12 reasons they can reject them. One of them for rejecting is they're dealing with conflicting laws. So think about that. Most people are going to have an institution that is going to have to deal with some conflicting laws. So there's actually quite a lot to this, but that's kind of a short answer.
Okay, now she asks, well, financial, yes, she can understand that now, but do medical power of attorneys fail?
Medical powers of attorney are a lot less likely to fail. This is my experience with the medical community. If you have a medical power, even if it's not the latest and greatest, they tend to accept it because they want someone else to make the decision. Our experience is medical powers, they'll go out of their way to make sure that the medical power works.
Please tell them why or what happens if they don't have one, Rex.
If they don't have a medical power?
Mm-hmm.
Well, unfortunately, Terry Schiavo is a great example of that. Parents and husband wound up in litigation over who had the authority to take care of her. A medical power of attorney would have at least given one of them control. So, unfortunately, going to court. You're going to make the lawyers rich. That's really what happens.
Okay. All right. Oh, well, yes, there's another one. Okay. Oh, she says, great. Now she loved that.
Okay.
Okay. All right. Any other questions? Oh, yes. When Alan wants to know, when planning for a loved one's future long-term care needs, what all would you recommend? Medical power of attorney, trust, combination?
Oh, all 6 medical documents, a trust, and there's a number of documents that should go with the trust, a complete plan, and instructions in the plan, kind of like my mom had, that allowed my brother to select an institution for her, based on her criteria. So there's complete planning is really the answer to what happens if a loved one becomes incapacitated.
And Alan, that's a great question, because in January, that is the topic of the webinar that we're going to do. We're going to go through all those documents. So, Alan, great question. Okay. When would one do the initial will?
Well, if you want to know the best time to do it, when you turn 18. Because at 18, your family no longer has the automatic ability to do things for you. But I will tell you, we don't have a line of 18-year-olds lining up to do wills. Sadly, their parents discover if a child dies in college, that it can leave a real mess. But really, if you're old enough to be listening to this and you don't have a will, you're behind the times. You need to go get planning done.
Also, Rex, remember what happened to me too. Our son had that horrible accident at 19, and the doctor was not, the head trauma doc was not trying to be rude. This is going to sound rude, what he said to us, but he said, I don't owe you anything, because we did not have the medical power of attorney, any document signed for Chad. And he said that Chad was their client, not us. However, in his case, Chad had to have his leg amputated, so they had to have a signature, and Chad was obviously in no shape or form able to do that. But he made it very clear in that hallway that Chad was their client, not us. But that, and that's when we learned harshly that we should have taken care of that earlier. And had Chad not been in the Dallas area at college, been somewhere else, they probably wouldn't even have called us. Mm-hmm. I don't know. I mean, so this is why we do. I love that our firm does this, the College Student Protection Plan, because, but he's right. Anybody over 18, that just is one example, and it happened to me. So now, another question. What about a will that has life estate language in it?
Well, they're very useful in certain situations. We use life estates fairly frequently, not for everybody, but particularly for a surviving spouse using the home, and especially in second marriages where maybe, let's say, the husband owns a home, the wife moves in, he might give her a life estate in the home while she's alive so that she doesn't have to move out. But then it goes to his kids upon her passing or moving out.
Okay, let's see.
I see the next question. I'm in my 30s. My wife and I have an infant daughter. Where would you recommend a family start? Is it best to dive into trust, or would it a will? Well, there's so many things that you can do with a trust that you cannot do with a will. Something's better than nothing, but we have a lot of material and we can show you. We're happy to send emails out on, we got several possible handouts. If you'll just email Sheila and ask questions, we'll get you some information.
That's all I see.
Yeah, that's all I
That's
see.
all I see. Well, and I know you've got I know Rex has got something to go to. So if Rex, thank you. I'm going to thank Rex first so he can go on to what he needs to go on to. I'm sure you'd love to have a few minutes to get on your call. Thank you,
Okay,
Rex. Great
you're
job.
welcome. And I think I still have control of the slides. So,
Okay, well, if you just once you back out, it will.
There you go.
Oh, there you go. I'm sorry. Yes, thank you so much. And if you could, I think I can. Let me see. I don't know that I can control from here. I don't know that I can. Okay, well let's do this real quick. Sheila, do you want to go over the CEUs?
Sure. Yeah, because someone already sent me forms that today. Well, they're not the right forms. It's not even the right webinar. I don't know why they sent those or where they got those, but it's certainly not the right ones. So I will send Marty these, the eval and the sign-in sheet just shortly after we get done here. And then he will send them to you in a follow-up email. You will send them, fill them out. I've had people send them blank, Marty. So fill them out and send them back to me at sheila@heymanhogue.com. And then I will be happy to email you your certificates.
Yes, yes, yes. Make sure you save them after you put the information in there, so that they're when you attach the file, it's already been saved. Because if you don't save it before you attach the file, you're going to be sending an empty document. I've done that before. Guilty. So in addition to that, we have a Google survey we're going to ask you to complete. It should pop up for you, or an option should pop up for you as you log out. If it doesn't, you'll also receive that in the final email as well. Rex, can you go to the final one real quick? I'm sorry.
all right.
I'm glad you thought of that. Our next webinar is on, with Heyman Hogue is on the January 16th, and we're going to talk about a New Year's resolution really for everybody. Important legal documents every adult needs, and they're going to go through the list of documents and all of that on the 16th. But Sheila, thank you. Rex, thank you very much.
Have a wonderful Merry Christmas, everyone. Safe and Happy New Year, too.
Merry Christmas, everyone.
Happy holidays. Thank you, everyone. We'll see you on the 16th of January, hopefully. Take care.